but the seminar ran on. So thank those members who attended the seminar. I thought it was really useful again, actually. Some really interesting thrown up in the Justice Seminar, particularly around that area of social media. I spoke to a few people afterwards as well, and I think it would be useful if we schedule in one of the seminars on social media, because it's such a live issue and such a complex issue. It probably deserves a seminar of its own, so we'll maybe look at doing that after the summer and schedule that. But thanks again for those who came along. I know some people couldn't make it. Agenda item 1, apologies. We've received an apology from Edwin Poots. Is there any other apologies? Stuart Dixon maybe as well. Okay. Agenda item 2 then is draft minutes for the meeting held on the 12th of May. You'll find the draft meeting minutes pages 5 through to 9 of your meeting folder. If you want to just glance your eye over those and indicate if you're happy enough for me to sign off. Okay. Yeah. Happy enough? Yeah. Okay. Thanks. Okay, then agenda item 3 is matters arising. Item 1 is correspondence from the Northern Ireland Human Rights Commission regarding the abortion amendment to the Justice Bill. Consideration stage of the bill is scheduled to take place on Tuesday the 2nd of June. The Human Rights Commission has provided a copy of the letter it sent to the Minister of Justice asking the Department to oppose the abortion amendment to the bill that the committee agreed to table at consideration stage. A copy of that letter is at pages 11 through to 20 of your meeting folder. That's just really for noting. Item 2 is correspondence from the Department on clause 86 of the Justice Bill. Can I refer to pages 3 through to 11 of your table pack for correspondence from the Department regarding the committee's position, or the committee's opposition to clause 86 of the Justice Bill, and the relevant extract from the committee report. The Executive discussed clause 86 on the 14th of May, and the Minister undertook to seek to address the committee's concerns. The correspondence outlines that the Minister's intention to include clause 86 in the bill as a safety blanket in case the operation of the legislation throws up any unexpected difficulties, and he notes the inclusion of similar provisions in other bills, as had we during our discussion, of course. The Minister has suggested that rather than oppose clause 86, the committee may consider amending it in order that the requirement for the affirmative resolution procedure be more clearly associated with clause 86. This can be achieved by moving this requirement from clause 87 and placing it within clause 86, and he's provided the wording of the proposed amendments. Initial advice from the bill clerk indicates that the proposed amendment does not appear to address the excessive breadth and discretion afforded to the Minister by clause 86, which is what concerned the committee when we agreed initially to oppose the clause. The amendment simply brings the affirmative procedure within clause 86 rather than including it in clause 87. The Department was therefore asked to clarify what the amendment does that 87.7b does not already do. They responded just with the similar argument that was in the letter. Members, I would ask if we would be content that we maybe have a discussion about this on Tuesday. We're somewhat limited in terms of what we do with this, but it would allow us to have a better discussion if we facilitate even half an hour Tuesday at some point, if members are happy enough with that. Yeah.
Chair, I attended the meeting with the Department, and I know there's someone representing your party and someone from Alma and Patsy's party, the SDLP, and the Legislative Council were present. So I just think they gave a broader explanation of the rationale, and if it was possible, I don't know whether or not they can appear in front of committees, but I think it would be of benefit if they were there and Tuesday for our discussion.
Yeah, I think it would be useful if they could do that. We can certainly invite them to do that and see if that's a possibility. I mean, like, the committee, I think, has made a point which is a valid one. I think it's up to the Department to explain to us the circumstances in which they would potentially use clause 86 and why it's necessary. So if we can agree to that meeting on Tuesday and the Legislative Council come up, I think that'll be really useful.
What time are you thinking of, Chair?
We'll need to figure that out, because there's the ad hoc committees in the afternoon. I know other people will be involved in another issue which of excitement which is happening on Tuesday. Yeah. We'll try to.
And procedure or speech one.
Indeed, procedures committee. I wouldn't want to step on their toes. Look, we will try to find a suitable time. I know because we're not meeting on Monday, other party groups are meeting on Tuesday morning as well. We will email out suitable times, and hopefully we'll get most members able to do that, and if there's any difficulties, it's to and fro a little bit, but leave that with us, and we'll email out some information on that if everyone's content with that approach. Item 3 then is PPS report by Keir Starmer. Can I just advise the committee that the PPS has advised that the Starmer report will be published imminently and the PPS has agreed to forward the committee office a copy of the report by email when it's published. The committee office will then forward a copy on to members. And the PPS advised in relation to the Attorney General report on the Adams case that Mr Putz had raised last week, that it's anticipating publishing that report in the next week or so. Item 4 then is correspondence we received from the Department on the Crown Court legal aid fees. The Department has written providing further information regarding the action it's taken to provide for legal aid for criminal appeals and the steps being taken to address exceptionality within Crown Court fees. Correspondence there is found at pages 12 through to 14 of the tabled pack. Members will be aware of the media reports regarding legal action against the Minister in relation to the Crown Court legal aid remuneration rates by solicitors and barristers and the withdrawal of services by some solicitors. So if members are agreed, we could write to the Minister requesting information on legal action being taken, the likely short-term and longer-term impact of the withdrawal of services of some solicitors, and what action the Department is taking in light of these developments. If members are happy enough, we take that approach. Okay. Item 5 then is the forward work programme. The Department has indicated it intends to defer the oral briefing scheduled for the meeting on the 4th of June on the results of the consultation on unduly lenient sentences and propose next steps to a later date as more time is required to consider the policy issues raised in the responses, and the Animal Welfare Lobby has requested extra time to respond to the consultation. The briefing is now unlikely to take place before the summer recess. So we move on then to agenda item 4, which is our oral briefing. Just to remind the committee that in November 2014, the Department wrote to the committee to advise that it intended to pause the introduction of proposed legislation to give effect to the policy of removing all children from prison service custody at Highbank Wood Young Offender Centre, and the committee agreed to schedule an oral briefing on the postponement of the legislation. Department officials will attend today to discuss the postponement of the proposed legislation and the planned wider review of both community and custodial sentencing, which will take the form of a scoping study and which the Minister formally announced on Tuesday in an oral statement to the House. The relevant papers can be found pages 22 through to 86 of the meeting folder, and the Hansard of the Minister's oral statement is at pages 22 to 29 of your tabled pack. So if we can invite the officials to the top table. Okay, can we welcome Declan, Phil, Mary and Kira. If you want to maybe introduce yourselves very quickly for Hansard, and then whoever wants to lead off, and then we'll open up the questions afterwards.
I'm Phil Tooze, I'm Director of Woodlands Juvenile Justice Centre.
I'm Declan McGowan, Chief Executive of the Youth Justice Agency.
Ciara Lloyd, Head of Reducing Offending Policy, Department of Justice.
Mary O'Hay, Director, Youth Justice Services.
Great. Declan.
Thank you, Chair. And we are grateful to have the opportunity to brief the Committee on the Minister's plan for scope and study on youth justice, which will also incorporate the issue of custodial arrangements for children. I know that you have received a written briefing note in advance of today, and I know you will have heard or read the Minister's statement on Tuesday, so I do not intend to make these introductory comments very long, as you will already be familiar with the background to the announcement. My intention this afternoon is simply to provide some further detail on how this work will be taken forward. Following a public consultation on the custodial sentencing framework and approval by the Justice Committee to proceed with proposals, the Department began to identify the necessary changes to legislation to establish the proposed new arrangements. This included the permanent removal of children from Highbank Wood and the creation of revised custodial arrangements for under 18s. What became clear through this process was the extent and complexity of the legislative changes which would be required to underpin a principle that would not result in any material improvement for the majority of children who come into contact with the justice system. Administrative arrangements have meant that no young person under the age of 18 has been held in Highbank Wood since November 2012, and you will have heard the Minister give a firm commitment that this will continue to be the case. Whilst there is still a need to introduce legislative provision to remove under 18s from Highbank, our aim is to do this in a way which improves and simplifies the current system, rather than merely adding to its complexity. For this reason, members will be aware that the decision was made last November to pause the introduction of the proposed legislation and instead consider a larger scoping study which would consider the wider field of youth justice and allow us to put in place an innovative agenda for action which will make a real difference to the lives of children. The overall aim of this exercise will be to consider the structure and delivery of the youth justice system and how efficiently it addresses the many and complex needs of the children who come into contact with it. The exercise will look at 3 interrelated strands. Firstly, we will take a radical look at the sentencing framework with a view to simplifying it and streamlining it. Secondly, we will consider the overuse of the Juvenile Justice Centre at Woodlands for non-sentenced children. And thirdly, the scope and study will encompass early engagement, specifically the way the system organises itself to respond to the needs of young people on the verge of offending behaviour. Providing early support to these children is vital in helping them to alter their life course, as research shows that once a child has entered the formal justice system, it is very difficult to get out of it. In fact, we've already anticipated the need for a scope and study to address this issue and have made a successful approach to the Early Intervention Transformation Programme of £450,000 of funding over the next 3 years to pilot an innovative early intervention project which will enable a youth justice agency to deliver meaningful interventions and a wraparound support for children to prevent further offending behaviour. I will chair the steering group which will oversee all of this work. This steering group will have representation at senior level across the criminal justice system, including the Court Service, Probation Board, EPS and PSNI. Key departments involved in children's lives, such as DHSS and DE, have also been invited to join the group, which will provide direction and oversight, along with subgroups being commissioned to research, benchmark and provide evidence-based proposals to the main group. I should add at this point that we are currently developing terms of reference for the steering group, which I am happy to share with members in due course. Each of the subgroups which will be established will liaise with key stakeholders across the community, including children and young people, as they draw together their proposals for the steering group. You will also note that the Children's Commissioner has agreed that her office will offer guidance on the overall proposals at key stages in the development process. It is our intention to have a series of recommendations available for ministerial consideration by the end of February 2016. To guide us through this process, we will develop a timeline of key actions, which I am also happy to share with committee members, along with the terms of reference I mentioned earlier. This is a challenging timeframe, but as you might expect, the announcement has already generated significant interest across the criminal justice family and beyond. They all recognise, as we do, that this is an exciting opportunity to continue the work begun by the Youth Justice Review and to redefine a system that will improve the outcomes for the children involved, as well as their victims, their communities and society as a whole. I hope this run-through has given members an idea of our plans in taking forward this scope and study. I and my team are happy to take questions and provide further clarification at this point.
Okay, thank you very much. I'm sure you're aware that the committee is also engaged in our justice seminar series. We're looking at innovation and particularly around youth justice as an area that we think that there's new approaches could be taken. If there's areas that we could get agreement on as a committee that we believe would feed very well into this, or is the steering group going to be open to suggestions from our justice seminars, or is there somebody from the steering group who would even be willing to come along to our seminars and see if there's ideas that they may wish to incorporate?
Sure, absolutely. I mean, the whole team has been at the first two, and in fact we were reassured by some of the ideas coming forward that they lined up very well with what we were intending to do. But by all means, the steering group has a very much open agenda to look at the most important issues. So if those issues come from that group, we'll of course feed them into it.
And in terms of the buy-in from both health and education, I think there's an acknowledgement from all of us that the early intervention stuff will help prevent young people getting into the criminal justice system at later life. Aside from senior officials being part of the discussions, is there any sort of commitment at this stage in terms of finances being put forward from those two departments to make sure that that wraparound service is something that can actually be seen on the ground?
We haven't got any agreements per se, but we certainly have an agreement to work closely with us on the challenging issues. And certainly I've taken comfort in the last 8 months since I've been in post that the discussions I've had with education colleagues and health colleagues is that they're willing to come to the table with us and certainly work with us. In recent days, we've had the Minister for Education down in Woodlands to look to see what his team can do. For example, we work closely with health colleagues on trying to map ideas going forward that address both of our needs.
And just finally, before opening up to other members, I think there was a point that Sammy Douglas had made during the oral question. I'm sorry for stealing it off him, but he made the point of why we're waiting so long. Why has this not been done before? I mean, there was recommendations made before. Why in the delay in coming forward with this now?
It's a fair question. I would suggest that there's been a lot of progress over the last couple of years. It hasn't been a case of Youth Justice Review and we've stood still. What we've done is we've implemented some very innovative ideas which colleagues around at the side of the table can elaborate on. So there has been already improvements such as youth engagement clinics, such as the idea of working in proportionality, such as looking at ISSP, etc. And we will continue to do that through the lifetime. It's certainly not going to be the case that we will wait till February next year and then decide what to do. If and when things come to the table that are quick wins, we'll get on with it.
Okay. I'll give Sammy time to think of another question. Patsy?
Thanks very much, Chair.
If you could read my mind.
Just taking you back a wee bit, and we hear, and it's all very laudable, the items that you have mentioned there, but we had a comprehensive overview of the youth justice system in September 2011. So could you tell us what's the difference in this scope and exercise? Well, because a lot of the themes, the key thematic areas that you're talking about, were already talked about. So could you tell us, is this just a review of a review, or is this going to be something meaningful?
This is building on that review. I mean, it's fair to say that there were a lot of recommendations that came forward in Youth Justice Review, some of which have already been implemented and have progressed well, but there are other ideas that are still to be delivered upon, and this is an opportunity, I believe, to get everyone around the table and say, right, what are the key issues, let's crack them and let's move forward now. So we have made progress to a point, but we have a journey to go, and this is continuing that journey.
Sorry, if you forgive me for asking, but are those key issues different to the key issues that were previously identified? I would be very suspicious that they'll be the same.
They'll be the same.
The question being from that, is this just going to be another round table of saying, here guys and gals, let's have another thought process about what we already know to be the case, or in other words, why can't you just not drive on with it?
Well, I mean, what we want to do is get to a point where we all know what the issues are, and what we intend to do at the first meet of the steering group is outline the progress to date, and then look to see what further progress needs to be made in moving forward in this group. If all agree that we've kind of tackled everything, then of course we don't need to go any further. My sense, and certainly being in the post over the last 8 months, is that there's still a journey to go on some of the areas, such as paced remand and areas such as that. So my sense would be that those would be areas that we'd want to crack, and with the goodwill that we have generated, this is the time, I think, to do that and complete it.
One of the other things I would say is that the identification of the problems in terms of case numbers, the use of remand, the overuse of bail, and all of the work that was done in Youth Justice Review to identify problems. What we're now proposing to do is not take that to the next level of identify the problems. We did in the recommendations, and we did in our response to it, look at what we could do to implement it. This is, in a way, a chance to pull together the entire criminal justice system and look at it from the base problem of, this is the identification of the problem we've identified. How can we creatively, with no holes barred, considering everything on the table, including whether it leads to legislation, including whether it's a strategic change, even if it's a shift in responsibilities amongst the criminal justice partners, look creatively at how we can fundamentally get to the heart of what the problem is and fix it.
I can just say,
begs the question, why wasn't that done before?
I think a lot of the issues have been taken on board, and we certainly preempted a lot of issues that came up in the Youth Justice Review, for example, involvement in diversion, proportionality, etc. All of those innovations have been going on. It's just about legitimising those now and maybe placing them within legislation. So we have been innovative over the last 3 or 4 years, and all these things are in place. For example, youth engagement clinics. It's now about setting a framework around that and legitimising all of that work.
So, then back to the steering group. What's its composition, please, just?
Okay, well, what we will have, it'll be chaired by myself, and colleagues around the table will also sit on that. We will have membership from the criminal justice family, PSNI, PPS, and then internal bodies such as court service, etc. So that will be the composition of the justice family, and then we will also invite and have invited education and health to sit on that group. So that will be the steering group.
And the input, obviously, then from the voluntary community sector.
It's critical to this, and certainly in the course of the last 4 to 5 months, since Minister's announcement in November, we've taken the opportunity to meet with what we believe are a lot of the key groups out there to get their sense of how we move this forward. There's certainly, in my view, and I know I'm speaking for them, there was certainly an appetite to do this, and there was an appetite for them to get involved. So we've taken their views, and they will be involved through the subgroups that will look at particular themes and go and consult with those and hear their voices.
And then, just finally, to avoid any scepticism or anything about this is a review about a review and all that, have you a time-based sort of limit as to when you anticipate outcomes to the deliberations and what those might be?
I mean, as I outlined in my opening remarks, I mean, we wanted to look at how do we stop children coming into the justice system in the first place, how do we simplify the legislation, and how do we stop children going into woodlands who don't need to be there. We want to look at what are those issues and what proposals would be there to address those, and we want to bring that to the table by February of next year. And we have a clear timeline that we're developing at the moment so that we can touch base along the way to see what those issues are and how we can best bring them forward into a package in February of next year.
Is that not an awful lengthy period of time to determine what are probably, I'd be very, very surprised if there's going to be something bounce up that'll hit you in the face and say, oh, we didn't think of that, or the review didn't think of that those number of years ago. Are you not sort of giving yourself overly amount of time? I would venture to suggest 1 month could probably do this.
Well, I mean, it depends how you look at it. I mean, some people have said to us, some of the commentators from the stakeholder groups, that we're being overly ambitious in that time frame. It depends how you look at it. I mean, I could sit here now and say to you the three main strands are as I've outlined, but what I want to get to certainly as the chair of that group is to drill down into what are the barriers to this, why haven't they happened now, and how do we move that forward and get that collective will around the table to say, right, we've identified this as the issue, this is what we're going to do about it. I think if we did it as a 1 month piece of work, etc., we'd only be scratching the surface of it.
You seriously think it'll take 8 months to suss out what those issues are, given the expertise within yourselves and indeed other key stakeholders are going to be there? I'd be very, very surprised at that.
If
we just come from a briefing session up the stairs there where we dealt with a lot of complex issues. Knowledge, expertise was all in that room, and in a short space of time they were fit to distill those issues down into, and we heard reports back from the workshops. So I'm surprised it's going to take 8 months to do that.
Well, if it takes quicker than if it happens quicker than that, all the better. But what we want to do, I mean, it's not a case of come February of next year we've suddenly worked out what the issues are. There is a process that we want to consult with stakeholders, etc., in the autumn. So we will probably over the summer have worked out what are the key issues and, importantly, how we might move them forward. It's then about in the autumn meeting with the stakeholders and saying, well, how do we make these land? How do we bring them in so that they're all happening appropriately and are all doable?
To get this clear in my own mind, forgive me for saying so, these are stakeholders who are external to the steering group that you're going to consult with.
Internal and external, yeah. So we're going to consult with everyone who has an interest.
I'm just thinking, you're going to consult about, or you're going to review a review, then you're going to consult with people who are part of that review. You're going to consult with them as part of the steering group, and then you're going to consult with them again in the autumn.
Yeah, well, we're going to sit down as a steering group. We're going to identify what we think are the key pillars of work that need to be looked at in more detail. We will then task subgroups with going off and looking at that detail over the summer. They will then draw out what the key issues are in consultation with the key stakeholders on the ground. We will then start forming an idea around what the proposals are, which we will bring back to the steering group, but importantly also will bring to the key interest groups out there to say, this looks like the direction of travel. Is this what you would have had in mind?
Okay, thank you for that.
In the meantime, if I
Right.
could just add as well, operationally on the ground, the work will continue and the innovation will continue. The work isn't going to stop and start again in February.
No, I wasn't suggesting
Everything
that.
will go on, as I said earlier. It's about getting a framework around this and maybe a change in legislation, because our difficulty is this work goes on, but we draw from 5 or 6 or 7 different pieces of legislation. We really do need a more streamlined approach, which is part of the purpose of everybody getting together to say what is the one approach going to be.
All right, thank you for that. Thanks, Chair.
Okay, thanks. Raymond?
Thank you very much, Chair, and thank you very much for your presentation. My recollection, the Youth Justice Review team, pointed out many strengths of the Youth Justice sort of agency, if they want better words in that whole. So the recommendations was to improve or to assist just the strength of it. The Minister, when he was speaking the other day in the Assembly, talked about people could see this and maybe count it as a review of a review. So it's how we avoid that. So in terms of that, I mean, I made the point to the Minister, I think we need a clear understanding what needs to be done, who will be doing it, and the timescale. So how far are we on the road of achieving that?
What we are doing currently from Minister's announcement on Tuesday is devising both a timeline and a terms of reference for the steering group. Yeah. My sense is that in the next week or two those will be in the shape that we could circulate them, and certainly that's the commitment that I have given internally. So in short, before the end of the month or in the first week of June, really, we should be in a position that we could circulate and write to the committee to say this is the timeline of what we expect to do.
And would that include an implementation plan?
Well, it'll set out what we're trying to do over the next 8 months or so. What level of detail that goes into it, we haven't quite bottomed out, but we'll certainly have a look at that.
And I mean, I think Patsy made the point, and bringing, I mean, hours to the steering group. Are you satisfied that the other departments will, you know, fully participate in this, or see it as maybe, you know, something that they want to avoid in the short term?
The short answer is that I think they'll absolutely participate. I mean, in the last 24 hours, we had the Department of Education saying they're signing up to it, and just this morning, the Department of Health rang me to ask what level of grade to put on it, etc. So I think yes, they will.
And just on to go back to terms of reference, you're confident you'll have the terms of reference ready and in place?
I think we'll have the terms of reference in the coming weeks. Now the decision is whether we want to bring it to the first meeting of the group, which we're scheduling in for June, to get their sign-off before bringing it. But other than that, that'll be the only bar. We've already started drafting it.
Yeah, so like, you know, by the start of the summer, you know, we should be in place to have a very clear view of the pathway. Okay. And in terms of participation of young people themselves, rather than, you know, like, I mean, obviously the statutory agencies and the voluntary group, but how do you propose to involve young people in the shaping of this?
We're currently looking at that, but certainly drawn on my own experience of working on the community safety strategy, etc., where we looked at representative groups such as Participation Network and others to try and help us engage. We would probably look to that again and take their advice on how we best do that.
We would also say that whenever we talk about the subgroups consulting with stakeholders, that actually does include the children who are in the youth justice system and actually their parents. There's a very active group of parents who are involved in the youth justice system who provide advice and give us critiques about how we're operating, and they'll be one of the key bodies that we would go to, because it's a good way to reality test what we're proposing to do, to see whether the children themselves and their parents think that would actually help to, or would have helped to stop their children, or to enable their children to stop offending in the future. So absolutely they're vital to everything that we take forward.
Okay, so like, and the reason why I asked that is, I think the CGNI, the Criminal Justice Inspectorate, are perhaps due to do an hour report.
They are in the justice review.
So, I mean, would you be in the position, do you think, that, you know, the improvements that they sought from the last time are now in place? And
I would hope we've made progress. I mean, it'll come down to, I suspect, without having had an opportunity to discuss with them yet, what success looks like. I mean, they might look more at an outcome-based approach, where we might look at, you know, we've brought certain things and we've progressed them, but they might say, but where are the outcomes and how can you identify that? I think there might be a discussion of that, but certainly having a look down them, the vast majority of them have certainly been progressed because they've fed into this process.
okay, good luck. Thank you very much.
Shirley? Paul? Yes, thank you. I'll go straight in. This isn't a trick question. It's more from my ignorance than anything else. Don't worry. But where does the youth justice system start?
That's a good question. I mean, to me, it should start. I mean, I've always been of a view that from the moment a child comes into this world, they could, in theory, be brought into the youth justice system because of their circumstances. I mean, factually, the criminal age responsibility, you know, is 10, so it's not going to be before that. But because of their own circumstances, you can already start to identify indicators. And you know, we all know of children who are missing school or have problems at home with their parents, etc., or brothers and sisters of people who've been through the system. So it could start as early as that. And I was always of a view when I was in community safety that you really were starting to think about it from 0 to 9 months, because that's when the people need that wraparound service. And certainly through early intervention, we need to be working closely with people to make sure where those signs and signals are coming forward, we are there to address them at the earliest possible point in conjunction with all of the key players.
So thank you very much for your answer, because it has helped. But so where then does the Youth Justice Agency, where does that start?
It starts technically from the children coming in at 10 years old, but you know, what we're looking at the early intervention programme that we're looking at, and that pilot programme, we're looking to see if there are identification signals being identified to us that we need to be starting to look at. But formally, we're dealing with them once they're in legally through that age. Yeah.
Yes, as Declan has stated, 10 is sort of the earliest age group. That said, with our caseload, and we work with about 1,200 young people a year, only 7% of those are aged between 10 and 14, so the majority of the young people we work with are 15 plus. That said, we do want to start looking at the arena of early stage intervention as opposed to early age intervention. So it's not really a matter of a young person's age. Once they're over 10, we will work with them. But we want to look at the very early signs where they're going to start to display behaviours that may lead them to commit more serious offences, and our monies that we have received recently or will receive from Early Intervention Transformation Programme will help us extend our remit a little bit to work with those young people that are displaying very early stage offending behaviours.
I think part of the issue is that because of the nature of the child and how young they are, the police using diversion will, as much as possible, all of us want to keep children out of the formal criminal justice system, because we all know too well that the level of outcome that you can expect once you're formally in, worsen your life, get worse. So we all want to keep them out of the criminal justice system. Sometimes by using diversion without giving any kind of wraparound support, or being able to direct the children to the right services, whether that's statutory, whether that's the voluntary sector, whether that's community groups, whether it's children who are displaying antisocial behaviour that need to reconnect with their local community, for example. By merely not bringing them into the criminal justice system, we're not necessarily doing them any favours, because nothing's addressing what caused them to act that way in the first place. So what we're looking at doing is how we can actually get into that space without criminalising the child, without in any way bringing them into the criminal justice system, but voluntarily engaging with them, offering them the significant support that they can get from a qualified social worker who works on these issues with youth justice, who works with the PSNI, and can actually start providing that wraparound support with the view to actually saying, to not seeing them, because frequently what you have at the moment is you identify someone at the age of 8, 9 or 10, and Mary will tell you that you're almost guaranteed to see them with a more serious offence, with basically a series of increasingly more serious offending, and then you see them at 14 where they finally have to enter the criminal justice system because nothing has been done to address
At the risk of sounding really radical, is there an argument? If we're looking at actually looking at preventative sort of policies, is there an argument that actually youth justice would be better sitting in education rather than the Department for Justice?
You stole my third question.
You can think of a new third one in the time of the answer.
I mean, perhaps if I go answer that, I mean, I don't think it's a question of where it's located, but I understand and certainly the synergies of working closely with colleagues in education. I think as long as we're interacting properly and at the right time with the key bodies, I think it doesn't really matter where we're located. It's a question of making sure that we are joining up at the right stage of that child's journey.
Sorry.
No, you're okay, Chair. No, that's very, very intellectual. I maybe wouldn't have got there. Can I then, because it's a very, very interesting answer, and that's basically where I want to get to the crux of it, because I feel that whenever you get a child, it's too late. Now, you're not in control of this destiny. You're a massive part in it. And again, it's about where you actually start from and on a child's life journey. Speech and language therapy seems to be an issue that's cropping up, and I know the Chairman has raised this with the Minister. Over 50% of youth offenders seem to have speech and therapy problems, and I've experienced that myself and my own family, and I know how long it is to get onto a waiting list, then to be referred, then to be seen. Now, people don't offend purely because of that, but it must be a factor of building up frustration, and communication, the lack of communication must be a factor. Mental health must be another massive issue, that you're working against the tide as opposed to trying to stop the tide. What can you do as an agency to help and resolve this issue around waiting times and about services for children?
I totally agree with you on both of those issues. I mean, my sense is that we need to work as closely as possible with our health colleagues and other colleagues, but particularly health colleagues. And what we have in place currently is a good working relationship. And certainly I met with colleagues from health in recent months to outline some of the issues that we're dealing with. They're over the detail of that and have agreed that they will work closely with us. It is about doing it. We do have an initiative in place to deal with mental health, which Phil can elaborate upon, and on the speech and language side of things, I am meeting with one of the representatives from the Royal College of Speech and Language Therapists later next month in the middle of June, just to talk about how we might move forward, because I am conscious that we need to try and move this forward in the prevailing financial climate, but we're going to have a look at how we could do that.
There's a great word running about civil service land at the minute called, which is preventative spend. And whilst some of that stuff's risky and hard to justify, have you identified any ways of getting money down quicker to resolve the issue?
I think, in short, on the early intervention side of things, more generally, that's what we're trying to do. I mean, it really was a case several months ago, just at the turn of the year, where we felt that, yes, we're dealing well with children as they pass through the system, but we need to stop them coming in the first place. And that's why we actively sought the money from the Delivering Social Change Early Intervention Programme. And we've got that. That helps us move forward now and start to look at how we identify those signals and address them. We're also trying to look creatively at other funding streams that we might be able to draw down to address some of the issues and see if we can fund them using that, if only to get it as a pilot so that we can look at it to see if it's something that we might later mainstream when we get a good look at our budgets in the next couple of years.
It is important to get in at the early intervention, but when someone is in the system, they have to be looked after too, with regards to any needs they have. What is being done in our secure premises, Hyde Bank and various others, basically dealing with young people? What facilities are there, services are there that will assist in that? Because, as you say, if we don't deal with, if we don't solve an issue at 10, you'll see them again at 14 and 15, and that may be part of a problem that will be that could be fixed. So what's...
I can address, going back to the mental health point you were making. We've actually been working very closely with colleagues in the Health and Social Care Board and the Department of Health to set up a community forensic child and adolescent mental health service based in Woodlands, but delivering a service out into the community and linking in with the CAMHS teams out in the community. And this is an initiative where we're actually pooling resources, and we're actually probably cutting through some of the normal barriers. And it's early days in terms of recruiting some of the staff, but it's actually already operational, and there'll probably be an official launch at some point in time, because we still have a few key appointments to do. But I think it's a sign of departments and organisations working together to actually address some of the key issues in relation to mental health and offending. One thing I've noticed over the years, and I've been in this business for a very long time now, is that a lot of the young people that we deal with mental health problems don't necessarily respond in the traditional way to appointments being sent out. They tend to have often chaotic lives. Sometimes drug abuse is an issue as well in relation to that. So actually this service is going to be much more able to respond to in terms of providing assessments, linking in and supporting the CAMHS teams with a specialist degree of knowledge. This team is also going to when it's fully set up, provide a CAMHS in-reach service to Woodlands, so that you'll have dedicated mental health time to children who are actually placed within Woodlands. It is a significant issue. We did a snapshot a number of years ago in terms of which identified a number of children who were under the care of a consultant child and adolescent psychiatrist who were on quite a range of complex medications and experienced a number of serious difficulties in relation to their mental health. So it was in response to a number of those things that this strategy was developed, and it's, as I said, it is early days, but I think it's showing signs of promise. In terms of other aspects, obviously within Woodlands we have a school, so we have young people who have significant deficiencies in their education, in literacy and numeracy and ICT. They then take a minimum of 20 hours education a week. We're able to assess them and get them into education, often when they've not been in school for many, many years, and achieve quite significant results within a very short space of time. We'll also work very closely with their families, and so we have family intervention workers who will actually work with the families to try and overcome some of the more difficult and complex issues. Going back to the consultation point earlier, we've held a number of consultation events with children with our colleagues from the voluntary sector. Include Youth has been particularly good at holding consultation events with ourselves over the years, and we'll hold groups and meetings with children. So we would probably do that again, both within custody and the community.
Well, the new legislation, when it arrives, whatever it looks like, will that have running through thread? Will that have access for these young people to gain to support through with mental illness and with speech and language problems?
The short answer is I couldn't tell you if it's specifically going to say that, but certainly the suite of proposals that will come forward will look at not just the legislation but other proposals, will look at the full panoply of things that need to be done to help that child's journey through life, not through the system.
The Justice Minister approved spending on speech and therapy, speech and language therapy for Youth Justice Agency. Where did that go?
Well, I'm looking at the budget. I've looked at the budget for this year, and I have to make 12% savings on that. What we did was we took a zero-based approach and basically went from zero up of the pressing issues as we saw them in this next financial year. We then we aggregated the budget on that basis. We didn't include, and I'll say that up front, we didn't include the speech and language therapist at that point because I think there's more discussions to be had between ourselves and health about not just paying for it for 1 year, but how we mainstream this and make sure it goes forward on a year-by-year basis. What we're trying to do in year, and certainly we're looking at now, or other funding streams that currently exist within the department, whether we could draw down funding from it to look to see if we could fund it on a basis of maybe over the next year, and then look to see if we can work with health colleagues and others to see how we could mainstream this going forward.
And because of that, then, is there finances secured in the future to enable you or others to provide services around speech and language?
I think the best way for me to answer that is certainly that I have no doubt that I'll be aggregating up my budget for next year to see how we best deliver the services. If, and it sounds like it's starting to become, this becomes a key priority, then I have to look at that and possibly include it as a mainstream part of the funding.
If the money wasn't spent on speech and language therapy, where was it spent?
Well, I mean, we have the budget. We have a budget that was in and around 16.7 million or so. It was the budget that I had to aggregate towards this year. That went towards, and I'll do it in a very high level way. I mean, we put in and around 7 million towards the woodlands and the running of it, and then we had round about 6 million to the youth services side, and then the rest of it is your buildings and running costs and staff and all that comes with it. So that's largely how it was spread.
How much was allocated, or how much did the Minister approve on speech and therapy, speech language therapy?
The Minister didn't per se approve it. The budget was there, and I have a set budget, and I have to deliver against it. It wasn't a case of the Minister saying set aside X amount for that. It would have been more of a case of saying this is the budget that you have to live within next year, and you have to prioritise it as you see fit. That was how we did it.
How much would it cost us to get the speech and language therapist?
I couldn't tell you off the top of my head. I mean, I've heard various figures ranging from about 30 to 45,000, but I don't know.
And that will be split between the Justice and the Health Department.
Well,
the health Minister's indicated he's willing to contribute, isn't it? Is that right?
Well, the Health Minister has certainly indicated that he's happy that this proposal be looked at and move forward. I wouldn't want to speak for what he was going to go financially to it.
Thank you, Chair, and thanks, Declan and the team for their presentation so far. Maybe could you remind me, and in fact remind the committee, what a custodial sentence does to a child, children who are often very vulnerable anyway. And I'm thinking the damage that it can cause to children, but also the cost to the public purse, and reoffending as an example. And does it work? Those are sorts of questions I'd like to ask before I ask you, or answer before I ask you another couple of questions.
I think. What it does to the child, each child is going to be different in how they react to their experiences are going to be different. But is there a cost? The short answer is yes, and it's a high cost once they're really into the justice system. That's why we've started to turn our attention to early intervention, because we firmly believe that as many children as we can keep out of the system, we will bring those costs down and use that funding to redistribute to other things such as we've talked about in the last 5 or 10 minutes. So, in short, it is expensive once they're in the system, and it's particularly expensive once they go into the woodlands setup, because it is an institution that the child is in. So that's why, as early as you can get them to keep them out of that system, the better.
At the recent elections, our party produced a policy document. It was the approach to law and order, and we talked about tough but fair. Can we actually be tough but fair dealing with young children in terms of custodial sentences?
I think, I mean, You have to accept, and certainly I accept, that some children do warrant the punishment for their acts. That's a fact, and what we can't say is that, you know, treat them all in a homogenous way and that'll help the problem. Some people do need to be, the law has to come down on them, but what we're trying to do is, as much as possible, try to move away from that and help children so that they don't go through that system and don't come out with criminal records, etc. But inevitably some will, and some will have to.
I think it would be fair to say that there are children who end up in Woodlands who really shouldn't be there. There are ones who arrive there through routes that we would not like to see them arriving in. They have children there who are placed overnight because the majority of the time they have no family who will look after them.
Claire, sorry for interrupting. Could you give us a figure or percentage of those children who should be there, in your own estimation?
It's a tricky one to say. I mean, Phil can elaborate on it.
I agree.
But I mean, if you take on any one day, and certainly Phil will provide more detail, you have in and around 30 plus children on some days in Woodlands. I think it's fair to say that probably half of those are there on a sentence, but a lot of those are there on remand, PACE, etc.
Yeah, it roughly works out about a third on sentence and 2/3 not on sentence. And that's been a fairly consistent figure since I've been doing the job for the last 12 years. It shouldn't be that balanced, and that's one of the issues that we want to address. This is one of the issues that need to be addressed with all the different stakeholders and the people that we're going to have around the table that we were talking about earlier. In terms of, are the right children in Woodlands? Well, I think the criminal justice inspector probably, without giving too much away, would probably say yes, on the balance they are in terms of offending profiles. They're certainly far more serious than children that are bailed. But there would be some that I would question whether should be there, and they're sometimes there because of more pressing welfare issues, and it makes it difficult for them to be managed in the community because of maybe repeated breaches of bail conditions, and that they don't comply with the problems that brought them into custody in the first place and got them involved in offending, lead them to then coming back into custody. So it ends up being a bit of a vicious circle, really. So, but I think it has changed significantly, and this is one of the things we were talking about. You know, have things changed since the Youth Justice Review? Absolutely, they have. We work very closely with our colleagues in health. And we've been working closely to try and avoid young people from the care sector coming into custody unnecessarily, where they could be managed through another type of resource, either secure accommodation or intensive fostering of that type of ilk. And we've seen very few of the younger age group coming into custody now. And I think that's been quite a major success that we've actually achieved over the last few years.
Just a final question, Chair. I was at a committee meeting this morning of the social development, and the officials came along. They talked about working in a collaborative way and in a partnership way with community and body organisations. I think Ciara had mentioned that as part of this process you would be involved with, I think the question Raymond asked was about children and their families, but also other organisations as well. My question to you is what will that engagement be with the community and voluntary sector, and will that include those community-based responses to children offending, or the restorative processes, as an example?
Short answer is yes, it certainly will. I mean, what shape it will take will be guided by the steering group and others, but certainly I would imagine it'll be, I would hope and hope it would be the case that young people will feel that at the end of the process they were properly consulted on their families, because we do have those good networks to do that, and we will just be building on that. So yes, everyone who we think is a key player we will talk to.
Thanks very much. Thank you, Chair.
Okay, Tom.
Chair, thanks for the presentation. Just a couple of issues. You talked about health there, the cooperation with health. Is that really social services, or is it more general health?
It's a bit of both, but social services is obviously a key part of that. But we try to engage with health on a more general basis too, to look at all of the health factors. But
because one of my queries was around social services. How much work is there with social services in respect of these young people?
There's a lot, and a lot of our team are qualified social workers.
Yes, it's a confession, I am a social worker. So, but yes, we work very closely with colleagues in social services. So, for example, one of the first things we do when a child comes into custody is organise a meeting with the family, with the child, but also any other interested parties like social workers. They'd be heavily. We basically are planning for the discharge of the child the day they come in. So given that about a third of the young people often come from a care background, we would work very closely with them in terms of childcare planning. So and also we're
a third of the children.
Sorry?
A third of the children
yes,
would come from.
Yes, from a looked after background. So it's a significant part of it, and Mary would have a similar, probably a lower number in the community, but a number of those children, even if they're not looked after, would have a social worker.
They still would have a social worker, and there's very strong links in community services really with the trusts, and all the staff and work in the community are either youth workers or social workers within the agency. So there's that connection as well. So social work would be very much at the forefront of the work we do with young people.
Okay. And what's their view on proposals and how they're been taken forward? Have they given a view, or has it just been a department?
Nobody has been asked to give a view as such. I mean, what we did was we did have a group that met regularly, well, yearly, I guess, between health and ourselves to look at the issues, and we set out the piece of work that we were about to embark upon, and they said, yeah, we would absolutely be involved in that going forward and look at how we can help on the various strands that we've outlined. So they're keen to be involved.
Okay. And what about another group of people? Has there been any, I'm not sure about the consultation, whether you got any responses from victims, the victim sector?
My sense in all of this is, I mean, in short, victims are a key part of this, and I think the children, when they are perpetrators, there will be victims, but the children will be victims themselves of what has happened in their lives. So we can't progress this without looking at the victims. This has to be the child, the victim, and as I've outlined, society as a whole. So victims will play a part of this.
And they are a form, especially when it comes to some of the way that, I can talk more about this, but in terms of the way that the Youth Justice Agency approaches community sentences, it is actually restorative. It's about bringing the victim in and helping the victim to see an outcome, to see that talk to the child, for the child to face the consequences of what they did, have a direct conversation with their victim, and to come to a resolution which is acceptable to.
So is that work ongoing at the moment?
That happens the last 10 to 12 years, I suppose. Victim work has been at the heart of everything we do, and that will continue, and that certainly will change whatever outcome happens in February. Could we continue to build on that? Currently we have, I think it's 47% direct victim attendance at a conference, so the young person meets their victim face to face and comes up with a plan as to what needs to happen next, and that will remain at the cornerstone of whatever the outworkings of this new process will be.
So currently, what sort of percentage of victims of those activities would be involved in a young person's case? I know not all victims are involved. I'm assuming it's only a percentage, or how do you...
It's a percentage, but I think it's fair to say that we have the highest percentage across Europe and probably the US as well in terms of direct victim involvement, and we're very clear it has to be the direct victim. So out of our 1,500 or so referrals a year, where there is a direct victim has been hurt or harmed, 46 to 47% of the victims actually attend a conference, and a further larger percent participate in some way, should it be via a letter or via coming through a youth conference coordinator to give their opinion as to what should happen to the young person at the end of the process.
And is the evidence showing that is helpful from a victim's perspective?
We have every quarter we measure victim satisfaction, and every quarter is between 97 and 99% victim satisfaction with the process.
Thanks, Chair.
Okay, I think that's everyone. Nobody else has indicated, so okay, thank you very much. Appreciate your time. Okay, members, if we move on then, agenda item 5 is the Police and Criminal Evidence Northern Ireland Order 1989 Code of Practice. Raymond, is this the one?
We just want that deferred for a week. 7 days.
I'm happy enough to do that unless anybody else has any objections. If we defer that to next week, okay. Agenda item 6 then, refer members to page 433 to 446 of the meeting folder. Just to remind the committee that on the meetings on the 17th and 24th of September, the committee agreed that it was content with the proposed statutory rule to amend the rules of the Court of Judicature 1980, which govern practice and procedure in the High Court. The rule covers 3 separate subject matters that will give effect to the change resulting from the adoption of EU Regulation number 1215/2012, which deals with cross-border jurisdiction, recognition and enforcement of judgments in civil and commercial matters, prescribe the procedure to be followed in applications for the removal of the automatic notification requirements imposed by new provisions of the Sexual Offences Act 2003 on sexual offenders with convictions from states which are not members of the Council of Europe, and remove the automatic right of solicitors to anonymity in certain High Court proceedings which affect them. Such Rule number 2015/235 was laid by the Department on the 29th of April 2015 and is subject to the negative resolution procedure. There have been no changes to the policy content since the SL1 was submitted to the committee, and the examiner of such rules has indicated he has no issues to raise with regard to the technical aspects of the bill. So if members are content, I'll put the question formally that the Committee for Justice considered such Rule number 2015/235 the urge for the Court of Judicature Northern Ireland Amendment 2015 and has no objection to the rule. We agreed? Agreed. Item 7 then, can I refer members to pages 448 through to 484 of the meeting folder. Just to remind the committee that the Human Trafficking and Exploitation, Criminal Justice and Support for Victims Act 2015 requires the Department of Justice to produce an annual strategy on offences under Section 1 and 2, slavery, servitude and forced or compulsory labour and human trafficking. The Department of Justice has provided a copy of the draft Northern Ireland Human Trafficking and Exploitation Strategy for 2015-16, which, subject to the Committee's consideration, it intends to put out for public consultation in June, with the aim of publishing the final strategy by early October. The Department intends to continue to work to deliver the strategy during the consultation period. So again, if the Committee are content that the consultation to take place on the Human Trafficking and Exploitation Strategy 15-16 and consider it further then when results are back. Happy enough?
Great.
Okay. Agenda item 8, refer you to pages 486 through to 624 of your folders. Just to remind the Committee, Section 20 of the Human Trafficking and Exploitation, Criminal Justice and Support for Victims Act requires the Department to issue guidance on how a victim of human trafficking may apply for compensation, the grounds on which compensation may be paid, and the arrangements available to support a victim through the process. The Department has provided a draft leaflet and guidance notes to help victims of human trafficking to access compensation and complete a personal injury application form. The intention is to translate the leaflet into languages most commonly spoken by potential victims of human trafficking recovered in Northern Ireland. While the Department does not plan to translate the guidance notes into other languages, a draft online summary page to the guidance will be translated. The Department has consulted members of the NGO Engagement Group and the Organised Crime Task Force Immigration and Human Trafficking Subgroup on the content of the leaflet and guidance notes, and those that commented are content with the approach. Following consideration by the Committee, the leaflet and guidance notes will be posted on the Compensation Services website and will be printed in hard copy for distribution to the PSNI, etc. as required. The guidance will be kept under review. So let's just note the draft leaflet and guidance unless anyone has any particular comments or questions on it. If not, then move on to agenda item 9. Refer members to pages 626 through to 703. Just to remind the Committee that the Department provided the results of the consultation on the draft adult safeguarding policy for the Committee's consideration at the meeting on the 23rd of April 2015. 58 responses were received, and the Department indicated that the responses were generally positive in terms of the broad content of the policy. They also provided helpful suggestions to clarify or improve the policy, as well as identifying areas where some further consideration was needed. The Department also highlighted that there was a lack of consensus across all sectors, including among some of the leading adult safeguarding organisations in Northern Ireland, regarding the need for legislation to support and underpin the adult safeguarding policy. A range of views were expressed, with just under 60% in favour of legislation. Other respondents were of the view that legislation should only be introduced after further consideration of existing legislation and safeguarding arrangements, or if there was clear and compelling evidence that the existing legislation is unable to provide necessary protections. The Departments of Justice and Health therefore intended to take time to consider and explore the range of views expressed and attempt to reconcile them. In the meantime, they set out their views on the specific legislative proposals that were set out in the consultation paper. The Department has now provided the Committee with the final draft adult safeguarding policy for Northern Ireland, which has been revised to provide greater clarity and takes account of the consultation responses. The consultation report will be published shortly, and the Health and Justice Ministers intend to seek executive approval for the final adult safeguarding policy, with a view to launching it as an adult safeguarding event on the 17th of June 2015. The Commissioner for Older People in Northern Ireland has requested an opportunity to brief the committee on her report, Protecting Our Older People, a call for adult safeguarding legislation, and it had been agreed to schedule a briefing when the draft policy was available. So can I ask the committee, are you content with the final draft adult safeguarding policy, or has anyone any comments or information? Are we happy enough if we write to the Commissioner and see whether she wishes to make any comments either in written form, or if she requests to come in front of the committee, we could facilitate that? Happy enough with that approach, yeah?
Yeah.
Okay. Agenda item 10 then, correspondence. There's 2 items of correspondence, pages 706 to 711, and 3 items at pages 31 to 70 of the table pack. If I can just draw your attention, item 2 at page 709 is correspondence from the ad hoc committee that's undertaking scrutiny of the Northern Ireland Public Services Ombudsman Bill. The ad hoc committee would welcome the views of the Committee for Justice on the bill, and in particular provisions relating to justice elements. So if members are in agreement, we could seek comments from the department on the provisions of the bill that relate to justice and consider the matter further when that response is received. Happy enough for that? Yeah. Item 1, pages 31 to 62 of the table pack, is correspondence from the Minister advising of his intention to commence Articles 19, 20, 26 and 30 of the Criminal Justice Order 2008 on the 1st of June 2015. These articles provide for a conditional early release scheme, release on compassionate grounds, for a curfew to be imposed during the early release period, and for recall to custody in the event of a breach of licence conditions. The committee received information on these proposals in 2012 and 2013, with prison service officials providing an oral briefing on the 3rd of May. The committee noted the proposals in April 2013 and advised the Minister that individual parties may wish to express views directly to him on the issue. So again, if members are content, I would propose that officials are asked to attend next week's meeting to provide members an opportunity to ask questions or raise issues prior to the commencement of the articles. Are we happy enough with that approach? Okay, item 2 then, pages 63 and 65, is correspondence from the Department providing a press release that was issued yesterday regarding the new offence of paying for sex. The Human Trafficking Act places a duty in the Department to raise public awareness of the new offence of paying for sexual services before the change in law comes into effect. The Department has issued a press release and will add a page of information to the Northern Ireland Direct website. Again, just to ask members to note the correspondence which was circulated electronically yesterday. Item 3, pages 66 to 70 of the table pack, Criminal Justice Inspection NI report on a review of the Northern Ireland Environmental Agency Environmental Crime Unit. That's just to note, unless anyone has any further information that they require. No. Any comments on any other pieces of correspondence? Okay, then agenda item 11, Chairman's business. The only issue that I would report is that the ad hoc committee for the mental capacity bill met at the beginning of the week. I'm going to chair that. Patsy's deputy chair of that. We're meeting on Tuesday, and we'll draw up a list of witnesses to invite to get written responses from over the summer, and then we'll draw up a list of people for oral evidence as well. Agenda item 12, any other business? Any members, any issue to raise? No? Okay. Agenda item 13, time, date and place of the next meeting. We're meeting on the 28th of May, room 30 at 2 p.m.